Good morning, everyone, and welcome to the latest of Radcliffe Chambers Junior Programme of commercial webinars. In this session, we'll be looking at what, in our view, are the most significant civil fraud cases of the past 12 months, at least so far, barring any last-minute entrants. For those of you I don't know, I'm Alex Kingston-Splatt. I'm a barrister at Radcliffe with a commercial chancery practice which focuses on commercial litigation and arbitration, civil fraud and insolvency. Many of my cases involve some form of allegation of fraud, usually in a commercial context. And 2 years ago, I was junior counsel in the widely reported arena litigation involving what is believed to be the largest ever hire purchase fraud committed in the United Kingdom. Before coming to the bar in 2017, I practiced for 5 years as a solicitor at and litigator at a mid-sized city commercial firm, specialising in a broad range of commercial dispute resolution. I'm joined this morning by Harmish Mehta, who's a new tenant in Chambers, having completed his pupillage in October this year. He's been instructed in various commercial matters, and both during and in his life before pupillage, he assisted in various civil fraud matters involving cross-border elements and multiple forms of interim relief. I was lucky enough to be one of Harmish's pupil supervisors, and he was unlucky enough to be my first ever pupil. Despite that fact, I can attest to the fact he's a very talented junior barrister and would highly recommend that anyone instruct him where you need a junior for commercial work. Before I get into the first case, I apologise in advance if I break down into a coughing fit. I have the tail end of what 20 years ago I might have been able to describe as fresh as flu, but I think for now all I can hope for is simply man flu. So apologies in advance if I do have to pause to cough. If there are any questions, our email addresses will be provided on the final slide, and indeed they're available on the website. Because of the format of the seminar, of the webinar, it doesn't really lend itself to a discussion at the end, but do feel free to contact us if there are any burning questions later on. So the first case which I'm going to run through is the Dos Santos decision of the Court of Appeal just a few weeks ago. Now, everyone will have encountered this decision probably. It's been very widely reported, but it's worthy of note again because it redefined the test for what is required in order to obtain a freezing order. Of course, one of the many tools in a fraud litigator's armoury. Now, by way of reminder, the traditional test for an interim freezing order includes the following requirements. The overarching requirement, of course, in the Senior Courts Act is that it must be just and convenient for the order to be granted. Second, of course, is that there must be a real risk of assets being dissipated, unless, of course, what is actually being sought is a proprietary injunction as opposed to a simple freezing order. But third, and most importantly for our purposes this morning, as to what an applicant needs to show substantively about the merits of its case in order to obtain a freezing order, the traditional test which developed through the case law was this. First, the claimant had to show a good arguable case, and second, generally, that had to be one over which the English court would hold jurisdiction were it to be brought. Now, this last point has been eroded in two principal ways. The first, in fact, has nothing to do with Dos Santos, but is worth mentioning in passing. And that comes from a Privy Council decision in 2021 called Broad Idea and Convoy Collateral. So before that case, it was thought that the applicant for a freezing order would simply have to show that there is a good arguable case against the defendant. However, in Broad Idea, the council held that there was no principled reason to link the grant of a freezing order with a substantive cause of action, whatever its merit may be. That view was endorsed by the Supreme Court more recently in Wolverhampton City Council and London Gypsies and Travellers 2023. And there the court expressly held that the grant of injunctive relief in this context and other contexts is not always conditional upon the existence of a cause of action. Now, the rationale for that appears to be that because, unlike with an interim injunction, which is aimed at preventing the commission of a wrong, which is the subject of a cause of action, think, for example, of a prospective injunction to prevent a threatened breach of contract. A freezing order, by contrast, is simply to facilitate the enforcement of an actual or prospective judgment. The court, in that case, also referred to other types of interim orders, which of course do not require the existence of any substantive cause of action against the respondent at all. So consider, for example, an application for Norwich pharmacal relief, or similarly, an application for a banker's trust order or a Shabra injunction. Now, of course, in most cases of fraud, when a freezing order is being considered, there will be a substantive cause of action against the defendant. And so this brings me to the second point, which is what exactly has to be shown in order to demonstrate that in relation to such a case, a good arguable case exists. So what amounts to a good arguable case has often been thought to be a more stringent threshold than the usual merits assessment for other types of interim injunction. So under the classic American cyanamide test for general types of interim relief, of course, the criterion is that there must be a serious issue to be tried. This distinction was thought to be appropriate because of the draconian nature of freezing orders. So even in some recent case law, such as the famous Holyoake and Candy decision, that distinction was maintained as justification for that distinction. But that thinking is now thought to be erroneous. The bar is no more or less difficult to cross when seeking either a general interim order or a freezing order. The two tests, i.e. a serious issue to be tried and a good arguable case, are in fact to be equated. So a serious issue to be tried, thinking of the usual American cyanamide principles, is simply one that will meet the summary judgment threshold. So in other words, it must have a real as opposed to fanciful prospect of success. The judge in that assessment, therefore, does not need to be satisfied that the claim will meet and pass the balance of probabilities threshold of 51% when ultimately it is put to the test at trial. Now, in practice, this does not change much apart from clarify the applicable test for freezing orders. Although, of course, if you are seeking a freezing order that is on the borderline when considering the summary judgment threshold, there may, of course, be a significant hill to climb. But the decision is of interest in particular because the Court of Appeal at some length, and in particular Lord Justice Popplewell, highlighted the changed attitude of the courts to the grant of freezing orders. So firstly, the judge readily accepted that freezing orders are, of course, a very invasive method of protecting a claimant's rights. And he noted that in the past, such orders were famously described as one of the law's two nuclear weapons, the others being search orders. But he noted that the number that are now granted by the courts, in particular the High Court and the Business and Property Courts, suggests that this description is inapt. Given the way the world is going, it may turn out, of course, not to be. But as a result of Dos Santos, it's clear that the freezing order in principle has its justification firmly rooted in the protection of prospective rights and interests in what the courts term the enforcement principle. And although there are important differences between freezing orders and other forms of interim relief, the court has firmly established that there is no justification for a different and higher test when seeking a freezing order than any other type of interim relief. So the key takeaway from this case is that essentially the prospects that must be established in either type of application are essentially the same. It is no longer the case that a higher threshold must be crossed in order to obtain a freezing order on an interim basis. So on that note, I'll hand over to Harmish to discuss Al-Sadek.
Thank you, Alex. The appeal in Al-Sadek provides important guidance on legal professional privilege, and in particular the iniquity exception. Under that exception, legal professional privilege, whether that's litigation privilege or legal advice privilege, does not arise in the first place in relation to materials that come into existence in relation to a fraud, crime, or other iniquity. To provide some background on the facts of the case, The claimant had alleged that as a result of a criminal investigation carried out by the government authorities of the Emirate of Ras Al Khaimah, he had been detained unlawfully and in degrading conditions, and that the defendant law firm had been involved in the investigation. Two of the matters that were before the Court of Appeal are of particular interest. The first matter was, what is the merits threshold for the alleged case of iniquity that must be satisfied for the exception to apply? In other words, how strong must the case for iniquity be to engage the exception? The court held that, save in exceptional circumstances, this was a prima facie case test, meaning that on an assessment of the material available to the decision maker, importantly, that could be a party or its legal advisor conducting the disclosure, or it could be the court deciding on a disclosure application. The test is whether it appeared more likely than not on a balance of probabilities that such iniquity existed. This conclusion provides clarity where preceding authorities have lacked clarity. The authorities preceding Al-Sadek, as the court observed, provided support for a test based on the balance of probabilities, but often formulated the position in different ways, particularly by referring to a prima facie case or a strong prima facie case. And the comments in previous authorities were otherwise problematic as well. For example, the court in Al-Sadek identified three problems with the obiter comments of Lord Justice Longmore in Kuwait Airways Corporation and Iraqi Airways Corporation number 6, or often referred to as Kuwait Airways number 6. The first problem was that the comments in Kuwait Airways number 6 provided that if all one has is a disputed version of events, it will be difficult even to say that there is a prima facie case of fraud. The problem that the court in Al-Sadek identified is that it's difficult to understand why the approach should be in this way, because the existence of a prima facie case depends rather on the quality of the evidence disputing that case. The second problem was that the comments in Kuwait Airways provided that where the issue of iniquity is not one of the issues in the underlying action, a prima facie case might be enough. The Court of Appeal in Sadek identified that it's unclear why there should be a difference in approach between, on the one hand, cases where the issue of iniquity is an issue in the underlying action, and on the other hand, cases where it is not. And third, in Kuwait Airways, Lord Justice Longmore had said that the exception only applies in, quote, cases where there is a strong, I would myself use the word very strong, prima facie case of fraud. And this formulation is ambiguous as to the strength of case required, as the court in Al-Sadek identified. However, the Court of Appeal also in Al-Sadek, in its conclusions, built in a proviso related to exceptional circumstances. The court acknowledged that procedural considerations may arise where the court has to reach a provisional conclusion on incomplete evidence, which may result in harm in either direction if it turns out to be wrong. The court referred to the approach that's applied in interim injunction applications, where the merit threshold is relatively low and there is a balance of harm test to be applied. The court considered that approach to be unsuitable for the context of privilege. But the court's conclusion was that the proviso would be that there are exceptional circumstances where, on their particular facts, a balance of exercise may have a part to play where the exercise is possible. So the court did not identify what those exceptional circumstances might be because it considered that none arose on the facts before it. Further clarity will be useful in the future on how this exception operates. The court did emphasize that it didn't foresee the exceptional circumstances and balance of harm approaches being applied by persons other than the court. The court in Al-Sadek emphasized that it rather envisaged this proviso to be dealt with only by the courts. It also appears that what the court had in mind was that the balance of harm exercise would not displace the merits threshold for the iniquity exception, but operate as an additional test where appropriate. The second matter before the court in Al-Sadek was what the legal test was for the relationship between the communication said to be privileged and the iniquity that must be established for the iniquity exception to apply. The Court of Appeal in Alsadek concluded that where there is a prima facie case of iniquity, which engages the exception, there is no privilege in documents and communications brought into existence as part of or in furtherance of the iniquity. So this gives rise to two categories, either of which is sufficient, as part of or in furtherance of. The part of category will include documents reporting on or revealing the iniquity. Part of was preferred by the court to in the course of, because one, the court wanted to place no temporal limit on this wording and stated expressly that it intended not to exclude documents brought into existence in preparation for the iniquity. And two, in the course of may suggest that documents which would not exist but for the iniquity come within the exception. And the court thought that this would lead to too remote a connection justifying documents coming within the exception. The court also emphasised that there is a prerequisite to the exception applying at all. And this is a basic point, that an abuse of the lawyer-client relationship is necessary for the exception to apply at all. Therefore, on the one hand, if a document is brought into existence as part of or in furtherance of the iniquity, and if it came into the lawyer's possession simply as an incidental consequence of their retainer, the exception will apply. However, the exception will not apply if the lawyer was provided with a document for the specific purpose of seeking legal advice on whether the conduct concerned was unlawful. As a practical matter, Alsadek will be useful because it provides clarity for the application of the iniquity exception, and clarity which will be useful for those conducting disclosure exercises. And importantly, the court didn't envisage those conducting a disclosure exercise having to deal with the balance of harm test. I'll turn now to the lawyer and persons unknown. In the lawyer, the claimant alleged that he was induced by the fraud of the first defendants, being persons unknown, to transfer cryptocurrency to them, which the first defendants passed through a number of blockchain wallets before the seventh defendants, also being persons unknown, withdrew it as fiat currency. The judgment with which we are concerned is that following the trial of issues between the claimant and the seventh defendant, the claimant and the sixth defendant, which is one of the cryptocurrency exchanges with whom the seventh defendants are said to have held accounts. This is, of course, a fact pattern similar to that which has arisen in other crypto asset related litigation in this jurisdiction. And we can expect to see more of such litigation in the civil fraud space. And crypto asset related issues can arise even where the fraud was unrelated to crypto assets. And the blockchain has attractions for those who misappropriate assets, because one may participate in the blockchain pseudonymously, subject crypto assets to rapid successive transfers to mask their destination, and hold the keys to crypto asset wallets in an offline way, in much the same way as one holds bearer assets. The first point of interest in this case is that the court held that crypto assets are an asset to which property rights can attach. As is well known, of course, this is a finding that the courts have made on several occasions already in this jurisdiction. But Deloya is the first occasion on which such a finding was made after a trial. On the previous occasions, the finding was of an interim nature, reflecting how litigation relating to crypto assets in this jurisdiction has often related to interim remedies. It may also be noted that the Property, Digital Assets, etc. bill was introduced to Parliament in September. This is the bill enacting the recommendations of the Law Commission in its digital assets paper. But common law developments such as Deloya will remain important even in light of legislation in the form proposed being enacted. And the proposed legislation intends to confirm the position that has developed at common law and provides merely that a thing, including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither a thing in possession nor a thing in action. So it remains to for the courts to develop the relevant principles. And rulings such as Deloya will also be important because of their potential influence in other common law jurisdictions. And for example, there have been significant rulings before the Singaporean courts relating to crypto assets, in which those Singaporean courts have derived guidance from English decisions. I can turn now to, sorry, before turning to Tunstall, apologies, Alex, there's one more point of interest that I should discuss in De Lawyer. That was the discussion of following and tracing. So by way of background to these concepts, following and tracing are two distinct means of locating assets which are, or may be taken to represent, assets belonging to the claimant. They are concepts or methods used when a claimant asserts a proprietary remedy, in other words, by asserting a continuing beneficial interest in property. So following and tracing are not in themselves causes of action or claims or remedies, but they are a necessary means of a claimant locating the assets in which they claim an interest. Following and tracing are distinct. So following involves following the same asset as it moves from hand to hand. Tracing involves identifying a new asset as the substitute for the old one. The court in De Lawyer recognized that there can be different characterizations of what happens to a crypto asset when it is transferred. It could be said that the existing asset is destroyed, depending on the facts, and that a new one is created, or it could be said that the asset remains the same after the transfer. And if the asset remains the same after the transfer, this is referred to by the court as the persistent thing analysis. This was relevant to the court in De Lawyer because this had potential implications for the claimants using the following method. The following method involves following the same asset as it moves around. A claim that the same asset has moved around will be undermined if the crypto asset was destroyed and a new one was created. And the court decided the issue of whether the crypto asset was a persistent thing on the facts by applying the evidence, and in particular expert evidence. This reflects the analysis in the Law Commission's report on digital assets. In that report, the Law Commission explained that a universal position is not appropriate as to whether a crypto asset is a persistent thing. And it will depend on the nature of the transaction and the crypto assets and the technology involved, whether the persistent thing analysis is appropriate. As a practical matter, this shows that if in a crypto asset claim, a party is seeking to use the following as a method, it will be important to produce good expert evidence to further the persistent thing analysis. I can now turn to Tunstall Group. Thank you, Alex. This case merits a brief discussion. The claimant companies in this case had been the victim of an admitted fraud involving the unauthorized extraction of company funds by the defendant. Judgment had already been entered against the defendant, recognizing the claimant's proprietary interest in the misappropriated funds. The claimant company sought orders under the banker's trust jurisdiction, requiring disclosure of documents and information relating to assets of the defendant's family. There have been allegations that the concept of family assets had been used to cloak the assets of the defendant. And significantly, the orders were sought against the defendant's brother. The defendant's brother was not a party to the original proceedings, and he was an Israeli citizen and was a resident in Israel. The orders were sought in respect of documents and information located at least in part outside the jurisdiction. There was therefore a cross-border element, and the case is of interest because the respondent argued that in light of these cross-border characteristics, the court lacked subject matter jurisdiction. The court had regard to McKinnon and Donaldson, which is the common starting point for cases of this kind. In other words, where documents are sought outside the jurisdiction and there is an objection that the court lacks subject matter jurisdiction. In McKinnon, the court was asked to make a disclosure order under the Bankers' Books Evidence Act 1879 against an American bank which carried on business in London. And in his ruling, Mr. Justice Hoffman, as he then was, held that on principle, the court should not, save in exceptional circumstances, impose a requirement on a non-party outside the jurisdiction to produce documents outside the jurisdiction concerning business outside the jurisdiction. The principle that Mr. Justice Hoffman was referring to was that a state should refrain from demanding obedience to its sovereign authority by foreigners in respect to their conduct outside the jurisdiction. And Mr. Justice Hoffman held that the same principle applied to the banker's trust jurisdiction hence the continued reference to McKinnon in modern authorities. The claimants in Tunstall argued that the approach in McKinnon was outmoded in light of the modern environment of international business, which they said is usually conducted electronically. And they said that LMN and Bitflyer was relevant to this argument. I will return to LMN shortly. But the court held that the doctrine of subject matter jurisdiction remained apposite, but that the doctrine as espoused in the authorities, including McKinnon, did permit an order in respect of foreign subject matter disclosure to be made, where there was a sufficient connection with England or where exceptional circumstances applied. And the court considered that the circumstances of the case could fit into the approach set out in McKinnon, and that those circumstances justified an order being made. The judgment in Tunstall appears to push against the suggestion in LMN that McKinnon is inapplicable in certain circumstances. I can turn back now to LMN. LMN was relied upon by the claimants in Tunstall. LMN was a judgment of Mr. Justice Butcher, and in that case, there was an application for orders under the Bankers' Trust jurisdiction in relation to alleged crypto asset theft. Mr. Justice Butcher held that the approach in McKinnon was inapplicable because the location of the documents sought was not known. Their location might be of little significance because the documents might be electronic. And I quote, "The court is faced with novel challenges of fraud in relation to cryptocurrency transactions, and an approach adopted in relation to banks in 1985 does not seem to me to be apposite." So the claimant's arguments in Tunstall appeared to be a reflection of what was said in LMN and an adoption of it. It does bear note that in LMN, Mr. Justice Butcher relied also on the reference in McKinnon to exceptional circumstances, but his reliance appears to have been only the secondary reason, not the primary reason for the approach he took. The court in Tunstall considered that the concept of subject matter jurisdiction is still entirely apposite, and considered that McKinnon still provided the relevant guidance, and considered that McKinnon provided no blanket prohibition inhibiting the making of the orders sought. This is a welcome indicator that the approach in McKinnon need not be sidelined. It avoids the risk of a carve-out from McKinnon, which was suggested in LMN. Such a carve-out might lead to a lack of the caution needed when making orders with extraterritorial effect. There may have been a risk otherwise of the enthusiasm about combating fraud and crypto asset fraud, sidelining the important considerations laid down in McKinnon. It could also be said that in LMN, there was no need to suggest that McKinnon did not apply. Rather, as Mr. Justice Butcher recognised in his secondary reason, the approach in McKinnon sufficed because it allowed for exceptional circumstances to justify an order being made, even where there is an insufficient connection to England and Wales. And in LMN, the key circumstance was that it was not known where the relevant documents were, and therefore in which jurisdiction an application for an order would be most appropriate. It's rather likely that such a circumstance would just constitute an exceptional circumstance. It's likely an exceptional circumstance where the claimant is unable to identify where to bring its application, and it would likely be inappropriate to require them to make tentative applications in jurisdictions around the world without knowing which is the most appropriate. So that brings me to the end of my discussion in Tunstall, and I can hand back to Alex.
Thanks very much, Harmish. The final case in our whistle-stop tour is the very recent decision of the Court of Appeal in Hopcraft and Close Brothers, which was a decision in 3 conjoined appeals, all concerning the law of bribery or secret commissions. Before coming on to the detail of the case, let's just anchor ourselves in terms of what we mean when we talk about bribery and secret commissions. So the first point is, despite some historic confusion, bribery is a tort. It is not, as used to be the case, or used to thought to be the case, a subset of the law of deceit or anything else. It is a tort in its own right. The second practical point that people often confuse is that there is no legal distinction between a bribe and a secret commission. The only difference is that a bribe has connotations which are incredibly tawdry, and a secret commission is something of a euphemism for the same thing in law. There is no legal distinction, as I say. So as a matter of law, bribery requires three actors. It requires a principal, it requires his or her agent, and it requires a third party who is dealing with the agent, knowing that that person is an agent of his or her principal. And that third party has to be considering entering into some kind of arrangement, contractual normally, but not necessarily, with the principal. Obviously, it also requires a payment to be made by the third party to the agent without the knowledge of that payment on the part of the principal. But indeed, the law goes further than that, because even if the third party reneges on the promise of a bribe, the mere promise of a bribe alone will be sufficient for a finding of bribery. It is not necessary to establish the fact of payment. Now, as I say, the word bribery brings up images of sort of brown paper bags and officials being corrupted by their contents. But the tort doesn't actually require proof that the bribe, the payment, or the promise of payment actually influenced the agent in any meaningful or material way. That includes in terms of the negotiated deal or the terms of the contract which results from it, or otherwise. So it's not, for example, necessary to show that there is some causal link between the bribe and some material detriment to the principal as a result of it. Indeed, even if the contract can be shown to be positively in the principal's interests, if it was obtained in the context of a bribe being paid or promised, that in itself can be sufficient in the absence of any knowledge and informed consent by the principal to render the whole thing potentially voidable. And I'll come on to remedies in a moment. Now, as I say, the case law has developed a distinction between a fully secret commission, as they're called, and a half-secret commission. As the Court of Appeal commented in Close Brothers, this is something of a nonsense label, to be frank, because after all, something is either secret from the principal or it isn't. But what this distinction actually means is that there is a difference, or a potential difference, between a situation where the principal knows about the prospect of a commission but does not know the amount of it, or the circumstances in which it will be calculated and how it will be calculated. And that's a half-secret commission. And a fully secret commission is, of course, where the principal has no idea about the payment at all, or the prospect of payment at all. Following the decision of Wood and Commercial First Business in 2021, another decision of the Court of Appeal, it is no longer necessary, it seems, to establish that there is a fiduciary relationship between the agent and the principal. The court instead, in that case, commented as follows. The question is the altogether simpler one of whether the payee of the bribe was under a duty to provide information, advice, or recommendation on an impartial or disinterested basis. If the payee was under such a duty, the payment of bribes or secret commissions exposes the payer and the payee to the applicable civil remedies. No further inquiry as to the legal nature of the relationship is required. Now, obviously, this is an important point, because where we talk about agent and principal, that definition, of course, is broader than the classic definition of an agent and his or her principal. It can capture many situations where the common law would not make a finding of agency in the traditional sense, but nevertheless, the person who is, in the broadest sense, acting for the principal, in inverted commas, can be subject to duties in this context. That being said, where the commission is half secret, civil consequences will apparently only lie where the payment involved a breach of fiduciary duties, properly so called. That was confirmed in the case of Wood, and also in the earlier 2007 Court of Appeal case, one of the classic cases in this area, Herstanger and Wilson. Now, as I say, the remedies for secret and half-secret commissions are usually different. So any contract that's been tainted by a half-secret commission, usually, although the question is one of discretion, but usually will not automatically entitle the principal to all of the broad range of remedies that are available for a fully secret commission. So, for example, where the commission is fully secret from the principal, the usual remedy is rescission of the contract from the very beginning. So if the arrangement, for example, as a lot of them are, involves a loan, that will involve rescission of the loan agreement in its entirety, and with it, the obligations of the principal to pay interest to the third party and any other incidental charges arising under the instrument. Now, obviously, that doesn't mean that the principal can keep, for example, in the context of a loan, the capital money that was paid by the third party. The principal will have to give what's called counter restitution of that. So in other words, they'll have to give the loan money back. But of course, all of the other terms of the contract will fall away. And in the situation of a lender, the right to be paid interest at all will have to be pursued as an equitable right to restitution, which in the context of a bribe or secret commission, depending on the circumstances, may be quite difficult. But with half-secret commissions, instead of all that broad range of remedies, and of course, with both situations, the principal has the right to recover the amount of the bribe, has a claim to that bribe. But where it is only half-secret, that is the usual limit of the remedy involved, although the court, as I say, has a discretion as to the remedy to impose for any breach of duty. Turning to the case of Hopcraft itself, as I mentioned at the beginning of this involved 3 conjoined appeals, which were all based on very similar, although not identical, facts. In each of the cases, the claimants were financially unsophisticated individuals, as it was put, purchasing second-hand cars from car dealerships. Now, in each case, the car dealership had acted as a credit broker for these buyers, meaning that it assisted the claimants in obtaining finance to fund the purchase of their car. But they were also just straightforwardly the seller of the vehicle itself. So the dealerships in these scenarios had 2 separate roles. On the one hand, simply the trade seller of the vehicle, and on the other hand, credit broker on behalf of the buyer. The claimants all entered into finance agreements arranged by the dealerships with the defendant lenders, and the defendants paid discretionary commissions to the car dealerships in return for the arranging of that finance. Now, the commission structure permitted the dealer a degree of discretion as to the interest rate that would be payable under the finance agreement. And of course, the higher the interest rate that was set, the higher the commission or the potential commission that could be paid from it to the dealer. Now, in terms of the disclosure of this arrangement with each of the buyers, each of the cases differed slightly. So in one of the cases called Wrench, the lender's terms and conditions disclosed the possibility of a commission being paid, but it was set out in one of the clauses towards the back of the terms beneath the heading general, you know, the sort of place where one would expect to find things like non-reliance clauses, etc. In a case called Johnson, the lender's terms again disclosed the possibility of a commission, as did an additional document called a suitability document that was prepared by the broker. In Hopcraft, however, there was no disclosure in any of the documents by either the lender or the broker whatsoever. So in terms of the way this commission worked, in both Johnson and Wrench, unknown to the borrower, the broker and lender had entered into what was described as a tied arrangement. In other words, an arrangement under which the broker would give the lender, in other words, the dealer would give the lender the first right of first refusal on any financings, irrespective of whether or not that lender's product was suitable to the needs of the individual borrower. In Johnson, the broker also indicated in a pre-contractual document given to the buyers that it would carry out a suitability assessment and suggest a finance deal based on answers which had been provided to questions put to the borrower. So in doing that, it represented effectively that it was carrying out an assessment of a select and named panel of lenders in the document in order to find the most appropriate financial product for the borrower. I should say, incidentally, that each of these car finance deals was obviously regulated, and after the Court of Appeal handed down its decision, it's fair to say the FCA has got itself in something of a bother about this decision and has said that it will be monitoring it and the consequences of it in any appeal closely. So there may well be regulatory changes brought about as a reaction to it. Now, for context, there are two major Court of Appeal cases that I've already mentioned in passing in this area, which, as the court said in the present case in Close Brothers, are not always easy to reconcile with each other. The first dates from 2007 and is the Herstanger case that I mentioned, where the court found that a broker owed a fiduciary duty to the borrower and had disclosed the fact but not the amount of the commission being paid. While the Court of Appeal held that the partial disclosure, in other words, a half-secret commission, was not enough for the lender to escape liability altogether, it found that the partial disclosure of the commission was sufficient to negate secrecy. So it was a half-secret commission. The court said that in this type of halfway house category of case, as I mentioned earlier, the full armory of remedies is not available. But the lender was found nevertheless to be liable to the borrower in equity as an accessory for procuring the broker's breach of fiduciary duty by making the commission payment to the broker. The other Court of Appeal case, which is more recent, is the one I mentioned, Wood and Commercial First Business, where, as I've said already, the court held that it's not necessary for the broker to owe a fiduciary duty and be an agent in a classic sense for there to be liability, provided that the payment of the commission was fully secret. As I say, there is, at least on the case of the current state law, a distinction between the extent to which you have to show that the agent had a fiduciary relationship, depending on whether the arrangement was secret, fully secret, or half secret. Now, back to Close Brothers. The court confirmed that the car dealers in question owed a duty of disinterest in the sense set out in Wood, but also an ad hoc, as they described it, fiduciary duty to the claimants. And they said that that fiduciary duty arose in tandem with and in consequence of there being a duty of disinterest. So that appears, at least to my mind, to somewhat elide the two tests and to intermesh them. I think what clinched it for the existence of the duty of disinterest and possibly also the ad hoc fiduciary duty was this credit broking activities. So the court, of course, held that a duty of disinterest was part and parcel of the nature of those duties. And the court commented that the dealer simply couldn't comply with that unless they'd actually told their customers that they were prohibited, as a matter of contract, from acting impartially. Indeed, as the court commented, by the very fact of the tied arrangement, they were putting their own interests ahead of those of the customer, the antithesis of any form of agent or fiduciary. So accordingly, in the case of Hopcraft, that was found to involve a fully secret commission. And so the bank had primary liability to the customer as a result of paying it. In respect to the fiduciary duty, the court found that this arose from the nature of the relationship and, as I say, the tasks that the dealers were actually entrusted with. The court commented that the brokers were not simply carrying out a ministerial function, you know, a sort of, they were not simply acting as functionaries in order to obtain the finance. They were actually selecting and recommending the deal to their customers. The fact that in the Wrench case, the documents referred to the prospect of a commission with the amount said to be available upon request by the buyer was insufficient in itself to negate secrecy. The reality, the court held, was that there had been no disclosure of the commission whatsoever. Now, this point is to an extent consistent with other case law. So it appears that the mere fact that the terms and conditions of any lender suggest that a commission may become payable will not, without anything else, turn a secret commission into a half-secret one. Although that, again, can be seen as inconsistent, in my mind, with some of the cases as well. One of the other problems in this case, though, was that the term in question had not been adequately signposted. So, as I said earlier, the court commented that it was hidden in amongst a bunch of other terms. And the court expressly commented that whether or not a term is drawn to the attention of a customer can be a factor in deciding whether or not the commission was secret or half secret, though it commented that in itself that is not a decisive factor in making the distinction. So the lender in the Wrench case was in the same position as in the Hopcraft case, i.e. the commission was fully secret. So again, there was found to be primary liability on the part of the lender. Just in relation to the point about the disclosure that may be given in terms and conditions, one interesting comment given by the court, albeit an obiter dicta, was that, or dictum I should say, was that there is a distinction between terms in contracts which say that a commission will positively be paid and ones that simply say that it might be paid. Remains, of course, to be seen from other cases whether or not that distinction will be one of meaning. In Johnson, there was insufficient disclosure, as I say, of the prospect of a commission, and the parties in that case had agreed that this negated secrecy, and so at best it was a partial disclosure case, i.e. a half-secret commission. The question then was whether or not informed consent had been given. And the court's view was that simply telling the borrower that the broker may receive a commission was insufficient to amount to fully informed consent. As I say, the contract did not say the broker would rather than might be paid. Finally, in Johnson, one point of interest is that the court was asked to consider whether or not there was an unfair relationship within the meaning of Section 140A of the Consumer Credit Act between Mr. Johnson and the lender. Now, an unfair relationship, despite the relevant provisions being in the Consumer Credit Act, are not confined to cases where the Act applies in the sense that they are regulated agreements. They have a wider applicability than that and effectively require the court to examine the entire relationship from beginning to end. So the negotiations leading to it, the terms of the arrangement, and the methods of enforcement used if there's been any breach of the contract, in order to assess whether or not the relationship was unfair in total. And in that regard, the court commented that a relationship will not necessarily be unfair simply because the broker involved had received a commission from the lender and that there was no disclosure of that commission. Instead, the court, as set out in case law to do with Section 140A, will consider all of the facts and all of the circumstances and reach a conclusion. However, on the facts in Johnson, the relationship was found to be unfair by the significant amount of the commission relative to the sum that was borrowed, and also the fact that the true nature of the relationship between the borrower and the lender was, the borrower and the lender and the broker was not disclosed, and in fact was actually concealed by the broker. So overall, where does this leave us in this minefield of case law? Well, one of practical questions, certainly for the car industry and similar industries which operate in this way in terms of the arrangement of finance, is the nature and scope of the disclosures that are required to be given to ensure that a customer's informed consent has been obtained. Now, obviously, that is an incredibly fact-specific exercise. So reliance upon the multitude of high court cases that exist in different industries is unlikely to be safe in itself. But factors will include things like what industry you are dealing with, the financial sophistication of customers within it, whether or not, as was the case here, there is any kind of preferential or tied arrangement between the broker and the lender. And of course, the existence of any such arrangement, at least in my view, would create a very strong and obvious inference that there is a problem with in terms of bribery, but also the prominence and detail of the disclosure. Again, if there's a term that references the prospect of it, is it buried in the back? Is it on the front page of the agreement? Was it actually disclosed in any other document or any discussions that were had, etc.? But also the clarity of the explanation that's given of the broker's role to the customer. So again, in terms of takeaways from the decision, there are, in my view, two notable features. The first is that, as I say, the court expressed the view that references to the prospect of commission being paid that were buried in small print were not good enough, and gave a clear indication of its dissatisfaction with this approach. But secondly, also, the judgment makes clear that lenders can't rely on an assumption that the broker has made the required disclosure in line with the broker's duty, be it the disinterested duty or full fiduciary duty. The lender instead has to satisfy itself, again, depending on what exactly happens, that consent has been obtained. And of course, one of the safest ways of doing that is the lender giving full disclosure to the customer directly. Now, that point is in line with other cases and the general law of bribery, which are to the effect that the only fully informed consent will do, even if the broker assures the lender that it has made fulsome disclosure to the principal about what is going on. But of course, if it can be demonstrated that there has been fulsome disclosure and therefore informed consent, that will be fatal to any suggestion of bribery or secret commission. But from a lender's perspective, it is dangerous to place reliance upon the broker to fulfill that requirement, because it may not happen. It seems from the judgment itself, the Court of Appeal gave a heavy indication that really this area would benefit from guidance from the Supreme Court. And I tend to agree with that, because there are now at least three decisions in this area, Herstanger, Wood and Close Brothers, which the first two of which at least are arguably to an extent inconsistent with each other. And with respect, the decision in Close Brothers, as many people have pointed out already, may tend to add to that confusion. But of course, in the intervening period, Close Brothers is good law. And if you're dealing with clients who, whatever their industry, have payments of commission to third parties, it is worth examining the entire way that relationship works and the nature of the disclosures that are given about it. And of course, this is something which affects various different industries. I mean, for example, I'm dealing with cases at the moment in the commercial energy industry where brokers approach customers, offer to obtain good deals for their commercial energy contracts, and from that arrangement are paid commission by the energy companies themselves. And there's a whole slew of cases at the moment going through the courts. I'm involved in some of them where it is the borrowers are trying to allege that that involves a secret commission, and so the entire thing must be unravelled. And also they're trying to claim the commissions that were actually paid, which in some cases are very significant amounts of money. Again, it really does depend on the circumstances, because as matters stand, there are many conflicting cases in the county court about cases like that. And that situation, but there is a High Court authority to the effect that borrowers in that industry cannot rely on cases like Herstanger and so on. So it is a very difficult area of law, and one that, as I say, would benefit, I think, from guidance from the highest court in the land. Whether or not that will come from any appeal in Close Brothers remains to be seen, but I anticipate it's likely that we may see that in the next year or two, in which case we'll comment on it in the equivalent seminar next year. But that brings us to the end, just on time, of our run through of these cases. Thank you very much for joining us. I hope it's been informative. And as I say, it would be good to have some kind of interaction at this stage, but the format doesn't really lend itself to that. So if there are any queries, feel free to contact either or both of us, and we'll be happy to have a chat or come back to you about anything you may want to discuss. Thank you very much.
Thank you.